Okay, ngayon naman basahin natin ang civil procedure under pa rin ng remedial law. So, napakahaba nito. Civil procedure. Alrighty. Letter A, general provisions. Ito yung rule 1. Tama ba? Oo. General provisions ng civil procedure. So, section 3, rule 1. These rules shall govern the procedure to be observed in action, civil or criminal and special proceeding. Yan. General provisions muna bago natin pagtuunan ng pansin yung civil procedure. So, i-define na lang muna natin sila. A civil action, yan, kung saan mamaya pag-uusapan natin yung civil procedure mismo. A civil action is one by which a party sues another for the enforcement or protection of a right or the prevention or redress of a wrong. It may either be ordinary or special. Both are governed by the rules for ordinary civil actions, subject to the specific rules prescribed for a special civil action. Yan. Letter B naman, yung criminal action, ano naman yan, is one by which the state prosecutes a person for an act or omission punishable by law. Letter C, a special proceeding is a remedy by which a party seeks to establish a status, a right, or a particular fact. Rules are not applicable to election cases, land registration, cadastral, naturalization, and insolvency proceedings, and all other cases not herein provided for except by analogy or in a suppletory character. Okay, so mayroong tatlong proceedings, civil, criminal, and special proceedings. Tapos yung iba, may sarili siguro silang proceedings. Okay, magpunta na tayo sa nature ng civil cases, no? Bago yung dito magsisimula yung civil procedure talaga. Pero nakalagay siya sa Rule 2 ng Rules of Court. So, cause of action. Yan. So, every ordinary action must be based on a cause of action. A cause of action is the act or omission by which a party violates a right of another. A party may not institute more than one suit for a single cause of action. If two or more suits are instituted on the basis of the same cause of action, the filing of one or a judgment upon the merits in anyone is available as a ground for the dismissal of the others. Section 5, joinder of causes of action. Section 5, ito ng Rule 2. Okay. Joinder of causes of action. A party may, in one pleading, assert in the alternative or otherwise as many causes of action as he may have against an opposing party, subject to the following conditions. Letter A, the party joining the cause of action shall comply with the rules on joinder of parties. Letter B, the joinder shall not include special civil actions or actions governed by special rules. So dapat yung kung civil action ka, hindi ka magsasama sa joinder mo ng special civil actions. Letter C, where the cause of action are between the same parties but pertain to different venues or jurisdictions, the joinder may be allowed in the regional trial court provided one of the causes of action falls within the jurisdiction of said court and the venue lies therein. Letter D, where the claims in all the cause of action are principally for recovery of money, the aggregate amount claimed shall be the test of jurisdiction. Yan. Total amount claim yung magiging test ng jurisdiction. And Section 6, tungkol pa rin to sa cause of action, misjoinder of causes of action. Yan. Misjoinder of causes of action is not a ground for the dismissal of an action. A misjoined cause of action may, on motion of a party or on the initiative of the court, be severed and proceeded with separately. So, misjoinder of causes of action is not a ground for the dismissal of an action. Punta naman tayo sa Rule 3 o yung letter C dito sa binabasa ko, parties to civil action. Sino yung mga partido? Section 1 ng Rule 3, only natural or juridical persons or entities authorized by law may be parties in a civil action. The term plaintiff may refer to the claiming party, the counter-claimant, the cross-claimant, or the third, fourth, etc. party plaintiff. Basta may claim ka, plaintiff ka. The term defendant may refer to the original defending party, the defendant in a counterclaim, the cross-defendant, or the third, fourth, etc. party defendant. So yun ang tawag. Plaintiff, ikaw yung may cause of action laban doon sa defendant. So, bali ganun. Section 2. A real party in interest is the party who stands to be benefited or injured by the judgment in the suit, or the party entitled to the avails of the suit. Unless otherwise authorized by law or these rules, every action must be prosecuted or defended in the name of the real party in interest. Yan sinasabi niya. So, kunwari, meron akong claim na money laban kay A. So, ako yung real party in interest. Section 3, where the party is allowed to be prosecuted or defended by a representative or someone acting in a fiduciary capacity, the beneficiary shall be included in the title of the case and shall be deemed a real party in interest. A representative may be a trustee of an express trust, a guardian, an executor or administrator, or a party authorized by law or these rules. An agent acting in his own name joining the principal except when the contract involves things belonging to the principal. Ayan. Section 4 ng Rule 3. Tungkol pa rin to sa mga parties to civil actions. Ayan. Okay, Section 4. Husband and wife shall sue or be sued jointly except as provided by law. Section 5 ng Rule 3. A minor or a person alleged to be incompetent may sue or be sued with the assistance of his father, mother, guardian, or a guardian ad litem. So yung guardian ad litem is a person appointed by the court where the case is pending for a child who is a victim of, accused of, or a witness to a crime to protect the best interest of the said child. Section 6 ng Rule 3. All persons in whom or against whom any right to relief in respect to or arising out of the same transaction or series of transactions is alleged to exist, whether jointly, severally, or in the alternative, may, except as otherwise provided in these rules, join as plaintiffs or be joined as defendants in one complaint where any question of law or fact common to all such plaintiffs or to all such defendants may arise in the action. But the court may make such orders as may be just to prevent any plaintiff or defendant from being embarrassed or put to expense in connection with any proceedings in which he may have no interest. Section 7, parties pa rin ito. Compulsory joinder of indispensable parties. So, parties in interest without whom no final determination can be had of an action shall be joined either as plaintiffs or defendants. Ito yung mga compulsory o sapilitan na yung parties ay maisama sila. Indispensable kasi sila. Indispensable parties. Section 8, a necessary party is one who is not indispensable but who ought to be joined as a party if complete relief is to be accorded as to those already parties or for a complete determination or settlement of the claim subject of the action. So may indispensable party, may necessary party naman. Section 9, non-joinder of necessary parties to be pleaded. Whenever in any pleading in which a claim is asserted as necessary party is not joined, the pleader shall set forth his name if known and shall state why he is omitted. Should the court find the reason for the omission unmeritorious, it may order the inclusion of the omitted necessary party if jurisdiction over his person may be obtained. The failure to comply with the order for his inclusion without justifiable cause shall be deemed a waiver of the claim against such party. The non-inclusion of a necessary party does not prevent the court from proceeding with action, and the judgment rendered therein shall be without prejudice to the rights of the necessary party. Section 10. unwilling co-plaintiff. So if the consent of any party who should be joined as plaintiff cannot be obtained, he may be made a defendant, and the reason therefore shall be stated in the complaint. Section 11, misjoinder and non-joinder of parties. Neither misjoinder nor non-joinder of parties is ground for dismissal of an action. Parties may be dropped or added by order of the court on motion of any party or on its own initiative at any stage of the action and on such terms as are just. Any claim against a misjoined party may be severed and proceeded with separately. Section 12, class suit. When the subject matter of the controversy is one of common or general interest to many persons, so numerous that it is impracticable to join all as parties, a number of them which the court finds to be sufficiently numerous and representative as to fully protect the interests of all concerned may sue or defend for the benefit of all. Any party in interest shall have the right to intervene to protect his individual interest. Section 13, alternative defendants. Where the plaintiff is uncertain as to whom of several persons he is entitled to relief, he may join any or all of them as defendants in the alternative, although a right to relief against one may be inconsistent with the right or relief against the other. So napag-usapan na natin mga partidos sa civil actions. Dito naman tayo sa Rule 4, venue of actions. Venue of real actions. Yan. Actions affecting title to or possession of real property or interest therein shall be commenced and tried in the proper court which has jurisdiction over the area wherein the real property involved or a portion thereof is situated. Forcible entry and detainer actions shall be commenced and tried in the MTC. Ayan, pag-usapan natin yan kanina. MTC o Municipal Trial Court of the municipality or city wherein the real property involved or a portion thereof is situated. So basta forcible entry and detainer actions, kahit magkano yung halaga niyan, MTC siya. Section 2, venue of personal actions. And all other actions may be commenced and tried where the plaintiff or any of the principal plaintiff resides, resident defendant where he may be found at the election of the plaintiff. Okay, so venue of actions against non-residents naman. If any of the defendants does not reside and is not found in the Philippines and the action affects the personal status of the plaintiff or any property of said defendant located in the Philippines, the action may be commenced and tried in the court of the place where the plaintiff resided or where the property or any portion thereof is situated or found. Commercial lang, ingay ng mga kapitbahay natin. Section 4, when rule not applicable. So, kailan ba hindi applicable yung rule on venue of actions? Letter A, in those cases where a specific rule or law provides otherwise. And letter B, where the parties have validly agreed in writing before the filing of the action on the exclusive venue thereof. So, merong mga statute na nagpo-provide ng specific venue para doon sa action at meron din namang pagkakataon na pwedeng magkasundo ang parehong partido regarding sa venue kung saan nila bibistahin yung kaso. Okay, Rule 6, kinds of pleadings. Okay. So, ano ba yung mga pleadings allowed? Yan. The claims of a party are asserted in a complaint. Yan yung pinakasikat. Unang-una yan, complaint, counterclaim, cross-claim, third, fourth, etc. Party complaint or complaint in intervention. Diyan ilalagay yung cause of action mo, kung ano ba yung problema mo. Yan. The defenses of a party are alleged in the answer. Yan. Answer to the pleading asserting a claim against him or her. An answer may be responded to by a reply only if the defending party attaches an actionable document to the answer. So, nag-file ka ng complaint, sasagot siya, answer. pwede kang mag-reply kung meron lamang actionable document na nilagay siya ron sa answer. So ano ba muna yung actionable document? Nakakalito naman. A document is actionable when an action or defense is grounded upon such written instrument or document. Kung meron siyang depensa ron, so pwede mo sagutin ng reply. Kung wala naman, hindi na kailangan mag-reply. So i-define natin ang complaint. Section 3 ng Rule 6, complaint. Complaint is the pleading alleging the plaintiffs or claiming parties cause or causes of action. The names and residences of the plaintiff and defendant must be stated in the complaint. Section 5, defenses. So may dalawang uri ng defense, negative and affirmative. So negative defense is a specific denial of the material or facts. Ulitin natin. Negative defense is the specific denial of the material fact or facts alleged in the pleading of the claimant essential to his cause or causes of action. Affirmative defense naman is an allegation of a new matter which, while hypothetically admitting the material allegations in the pleading of the claimant, would nevertheless prevent or bar recovery by him or her. The affirmative defenses include fraud. Yan. Kunwari, totoong may utang ako sa'yo pero dahil yun sa fraud. Kunwari lang, statute of limitations, wala na akong utang sa'yo, nag-expire na. Mga ganyan. Release, payment, wala na akong utang, nabayaran ko na. Yun. Or illegality, may obligasyon ako sa'yo pero illegal pala yung pinagawa mo sa akin. Yan. Statute of frauds, estoppel, former recovery, discharge in bankruptcy, and any other matter by way of confession and avoidance. So pag sinabi palang affirmative defense, though inaamin mo na may claim siya sa'yo, wala naman na. Nabayaran ko na. So pag nag-attach ka ng resibo na nabayaran mo na kunwari, yung utang mo sa kanya, actionable document yun. Ganun ba yun? Tama ba yan? Parang ganun no? Affirmative defense may also include grounds for the dismissal of the complaint, specifically that the court has no jurisdiction over the subject matter, that there is another action pending between the same parties for the same cause, and that the action is barred by a prior judgment. So tatlo ang pwede mong ilagay na ground for dismissal sa iyong affirmative defense. Number 1, the court has no jurisdiction over the subject matter. Number 2, that there is another action pending between the same parties for the same cause. Ito yan yata yung litis pendentia. And number 3, that the action is barred by a prior judgment. So, Rule 7, parts of a pleading. Ano ba yung mga nakalagay sa pleading? Section 1, yung caption. Yung unang-una sa tuktok na gitna, yung Republic of the Philippines, MTC in cities, 3rd Judicial Region, Branch, Lapu-Lapu City. Yan. Doon naman sa right portion, civil case, number 4, kunwari, forcible entry, ganyan. Tapos sa left side naman, yung kunwari, si Janos is the plaintiff versus Joseph, defendant. Yan. So, yun yung caption. Tatlo siya. Tapos, yung section 2 ng part of the pleading, yung body. So, ilalagay mo doon, complaint. Tapos, comes now, the plaintiff by the undersigned counsel into this honorable court respectfully alleges that chorba, mga ganyan. Section 3 naman, yung signature and address. So, every pleading and other written submissions to the court must be signed by the party or counsel representing him or her. The signature of counsel constitutes a certificate by him or her that he or she has read the pleading and document, that to the best of his or her knowledge, information, and belief, formed after an inquiry reasonable under the circumstances, number 1, it is not being presented for any improper purpose as to harass, cause unnecessary delay, or needlessly increase the cost of litigation. Number 2, the claims, defense, and other legal contentions are warranted by existing law or jurisprudence, or by a non-frivolous argument for extending, modifying, or reversing existing jurisprudence. Number 3, the factual contentions have evidentiary support after availment of the modes of discovery under these rules. And number 4, the denials of factual contentions are warranted of evidence, or if specifically so identified, are reasonably based on belief or a lack of information. So, if the court determines on motion or motu proprio and after notice and hearing that this rule has been violated, it may impose an appropriate sanction or refer such violation to the proper office for disciplinary action on any attorney, law firm, or party that violated the rule. So, mahalaga pala yung provision ng signature and address. Actually, lahat mahalaga. Section 4, verification. Ayan. A pleading is verified. So, may signature and address na yung pleading. Meron pa siyang verification. A pleading is verified by an affidavit of the affiant duly authorized to sign said verification. The authorization of the affiant to act on behalf of a party, whether in the form of a secretary certificate or a special power of attorney, should be attached to the pleading and shall allege the following attestations. Ito yung hindi yung mismo, meron nag-act in behalf. Lalagay mo sa attestation mo, number 1, the allegations in the pleading are true and correct based on his personal knowledge or based on authentic documents. Letter B, the pleading is not filed to harass, cause unnecessary delay, or needlessly increase the cost of litigation. And letter C, the factual allegations therein have evidentiary support or, if specifically so identified, will likewise have evidentiary support after a reasonable opportunity for discovery. So the signature of the affiant shall further serve as a certification of the truthfulness of the allegations in the pleading. A pleading required to be verified that contains a verification based on information and belief or upon knowledge, information, and belief, or lacks proper identification shall be treated as an unsigned pleading. So, kailangan yung pleading mo ay verified. Verified na true siya. Hindi pwedeng gawa-gawa lang, kailangan may basyahan ka. Maganda pala lahat ng dokumento mo, talagang verified. Verified document, verified pleading, puro ganun. At so yun, parts of the pleading, no? After nung caption, the body, the signature and address, binerify siya. Tapos, mag-a-attach ka rin in-attach mo yung mga documents mo, in-attach mo yung power of attorney kung kailangan, o ng secretary certificate, ganyan. Kailangan mo pa ng certification against forum shopping. Yan. The plaintiff or principal party shall certify under oath, letter A, that he has not theretofore commenced any action or filed any claim involving the same issues in any court, and to the best of his knowledge, no such other action or claim is pending therein. If there is pending action or claim, a complete status thereof. Letter C, if he should thereafter learn that the same or similar action or claim has been filed or is pending, he shall report that fact within 5 calendar days. The failure to comply with the foregoing requirements shall not be curable, but shall cause the dismissal of the case without prejudice. So, hindi mo siya pwedeng ayusin unless otherwise provided upon motion or hearing. Verification for forum shopping, usually may nakalagay Republic of the Philippines sa left side, city of ganito, tapos sa gitna niya, verification and certification of non-forum shopping. I, Prince Ipio, Filipino, of legal age, single, and a resident of Chorva, after having been sworn in accordance with the law, hereby depose and say that, number 1, I caused the preparation of the foregoing pleading. Number 2, I have read the contents thereof, hereby attest Chorva. And number 3, to the best of my knowledge, there are no other pending complaint. And number 4, I undertake to promptly notify this honorable office if within 5 days from actual knowledge of any similar action or claim that may have been filed or is pending. In witness whereof, I have set my signature in this. Yan. Lalagay mo yung signature mo as complainant. Subscribe and sworn to me before this. Ganyan. Witness my hand and seal. Notary public. Yan. Panotaryo mo siya. Okay, magtungo naman tayo sa manner of making allegations in pleadings. Alam na natin yung laman ng pleadings. Doon na tayo sa Rule 8, manner of making allegations in pleadings. Okay, Section 1. In general, every pleading shall contain a methodical and logical form, a plain, concise, and direct statement of the ultimate facts, including the evidence on which the party pleading relies for his claim or defense, as the case may be. If a cause of action or defense relied on is based on law, the pertinent provisions thereof and their applicability to him or her shall be clearly and concisely stated. Section 7 ng Rule 8, action or defense based on document. Whenever an action or defense is based upon a written instrument or document, the substance of such instrument or document shall be set forth in the pleading, and the original or a copy thereof shall be attached to the pleading as an exhibit which shall be deemed to be part of the pleading. Section 11 ng Rule 8, allegations not specifically denied are deemed admitted. Section 12, affirmative defenses. Yan. A defendant shall raise his affirmative defenses set forth in Section 5B, Rule 6 and the following. So ito ilalagay niya that the court has no jurisdiction over the person of the defending party kung wala nga bang jurisdiction. The venue is improperly laid kung improper nga ang pagkakaano. The plaintiff has no capacity to sue. That the pleading asserting the claim states no cause of action kung wala naman talagang cause of action. And number 5, that the condition precedent for filing the claim has not been complied with. Ayan. Tungo naman tayo sa Rule 9, effect of failure to plead. Okay. Okay, saan na ba tayo? Ito. So, ito yung bago na to, alam ko eh. Whereas defaults allowed. Yan. If the defending party in an action for annulment or declaration of nullity of marriage or for legal separation fails, ito pag ang kaso mo ay declaration of nullity or legal separation, fails to answer, the court shall order the Solicitor General or his or her deputized public prosecutor to investigate whether or not a collusion between the parties exists, and if there is no collusion, to intervene for the state in order to see to it that the evidence submitted is not fabricated. Kasi bawal yung nagko-collude yung parties eh. Rule 10, amended and supplemented pleadings. Yan. Section 2, a party may amend his pleading once as a matter of right at any time before a responsive pleading is served, or in the case of a reply at any time within 10 calendar days after it is served. Section 3, Rule 10, amendments by leave of court. Substantial amendments may be made only upon leave of court, but such leave shall be refused if it appears to the court that the motion was made with intent to delay or confer jurisdiction on the court, or the pleading stated no cause of action from the beginning, which could be amended. Section 5, when issues not raised by the pleadings are tried, they shall be treated in all respects as if they had been raised in the pleadings. No amendment of such pleadings deemed amendment is necessary to cause them to conform to evidence. Section 6, supplemental pleadings. Upon motion of a party, the court may, upon reasonable notice and upon terms as are just, permit him or her to serve a supplemental pleading setting forth transactions, occurrences, or events which have happened since the date of the pleading sought to be supplemented. The adverse party may plead thereto within 10 calendar days from notice of the order admitting the supplemental pleading. Section 8, the amended pleading supersedes the pleading that it amends. However, admissions in superseded pleadings may be offered in evidence against the pleader, and claims or defenses alleged therein not incorporated in the amended pleading shall be deemed waived. Ayan, so makapangyayari na yung amended pleading, pero yung mga naisulat mo na sa ilalim na nabutasan ng kabila ay magagamit pa rin sa'yo, laban sa'yo. Rule 11, Section 1, answer to the complaint. So the defendant shall file his answer to the complaint within 30 calendar days after service of summons unless a different period is fixed by court. Section 2. Answered of a defendant foreign private entity. Where the defendant is a foreign private juridical entity and service of summons is made on the government official designated by law to receive the same, the answer shall be filed within 60 calendar days after receipt of summons by such entity. Section 3. Answer to amended complaint. Plaintiff files as a matter of right. The defendant shall answer the same within 30 calendar days from notice of the order admitting the same. Plaintiff files, nag-file siya ng complaint na not a matter of right. Defendant shall answer the amended complaint within 15 calendar days from notice admitting the same. It also applies to counterclaim, cross-claim, amended complaint in intervention. Yan. Third, fourth party complaint. Yan. Yun yung rule doon. Section 4, a counterclaim or cross-claim must be answered within 20 calendar days. Okay. Grabe ko, so, kung sasagot ka pala dito sa Pilipinas, ikaw yung respondent, defendant pala, yan. Sasagot ka within 30 calendar days. Kung foreign private entity ka naman, within 60 calendar days. Plaintiff files as a matter of right within 30 calendar days. Pag hindi as a matter of right, within 15 days, kailangan mo na sumagot. Pag counterclaim or cross-claim, kailangan mo sagutin within 20 calendar days from service. Section 6, a reply if allowed. Generally, reply is allowed only when the answer attaches an actionable document. It may be filed within 15 calendar days from service of the pleading responded to. Section 7, answer to supplemental complaint. A supplemental complaint may be, may be answered within 20 calendar days from notice of the order admitting the same. Section 11, extension of time to file an answer. A defendant may, for meritorious reasons, be granted an additional period of not more than 30 calendar days to file an answer. A defendant is only allowed one motion for extension of time to file an answer. So, isang beses lang siya pwede magpa-extend. Okay, so dahil mga pleading naman yung pinag-uusapan natin, isingit natin yung nilabas ng Supreme Court na efficient use of paper rule. So all pleadings, motions, and similar papers intended for the court and quasi-judicial bodies' consideration and action shall be written in a single space with 1.5 space between paragraphs, using an easily readable font size, a font style of party's choice, yan yung font mo, of 14 size font and on a 13-inch by 8.5-inch white bond paper. Ganon din para sa mga desisyon ng korte. The parties shall maintain the following margins on all court-bound papers. So, left-hand margin of 1.5 inches from the edge, upper margin of 1.2 inches from the edge, right-hand margin of 1 inch from the edge, and lower margin 1 inch from the edge. So, left 1.5, top 1.2, right and lower 1.1. Yeah. Every page must be consecutively numbered. Yan yung efficient use of paper rule ng ating Korte Suprema. So, Rule 12 ng Rules of Court. Purpose. Before responding to a pleading, a party may move for a definite statement or for a bill of particulars of any matter which is not averred with sufficient definitiveness or particularity to enable him or her to properly prepare his or her responsive pleading. If the pleading is a reply, the motion must be filed within 10 calendar days from service thereof. Such motion shall point out the defects complained of, the paragraphs wherein they are contained, and the details desired. Para bagang, ano ba kasing sinasabi mo? Hindi ko maintindihan. Cool. Ano ba yung problema natin? Bill of particulars. Yan. Section 5 ng Rule 12, after service of the Bill of Particulars of a more definite pleading or after a notice of denial of his motion, the moving party may file his responsive pleading within the period to which he was entitled at the time of filing his motion, which shall not be less than 5 calendar days in any event. So, isingit ulit natin yung rules on payment of docket fees. So, amount of damages paid for should be specified in the prayer. Kung nagkiklaim ka ng damages. Amount of damages paid for should be specified not only in the body of the pleading, but also in the prayer, and said damages shall be considered in the assessment and payment of filing fees. Without payment of correct docket fee, no original complaint or similar pleading is considered filed. Para maraw hindi na i-file yung pleading mo. Hence, amendment of such complaint or similar pleading or payment of docket fee based on the amounts sought in the amended pleading will not vest jurisdiction in the court. Okay, magtungo naman tayo sa summons. Ayan, summons. Fundamentally, the service of summons is intended to give official notice to the defendant or respondent that an action has been commenced against it. The defendant or respondent is thus put on guard as to the demands of the plaintiffs as stated in the complaint. The service of summons upon the defendant becomes an important element in the operation of a court's jurisdiction upon a party to a suit, as service of summons upon the defendant is the means by which the court acquires jurisdiction over his person. Without the service of summons, or when the summons are improperly made, both the trial and the judgment, being in violation of due process, are null and void unless the defendant waives the service of summons by voluntarily appearing and answering the suit. As a general rule, when a defendant voluntarily appears, he is deemed to have submitted himself to the court's jurisdiction. This is not, however, always the case. Admittedly, and without subjecting himself to the court's jurisdiction, the defendant in an action can, by special appearance, object to the court's assumption on the ground of lack of jurisdiction. If he so wishes to assert this defense, he must do so seasonably by motion for the purpose of objecting to the jurisdiction of the court, otherwise he shall be deemed to have submitted himself to that jurisdiction. Ayan. Okay, summons, Rule 14. Section 1, unless the complaint on its face is dismissible under Section 1, Rule 9. Ano ba yung mga dismissible on its face na complaint? No jurisdiction over the subject matter. There is another action pending between the parties for the same cause of action, and the action is barred by prior judgment or by statute of limitations. So, unless ganon, kung hindi naman ganon, the court, within 5 calendar days from the receipt of the initiatory pleading and proof of payment of the requisite legal fees, yung court will direct the clerk of court to issue corresponding summons to the defendant. So, anong nilalaman ng summons? The contents. Letter A, the name of the court and the name of the parties to the action. Letter B, when authorized by the court upon ex parte motion, an authorization for the plaintiff to serve summons to the defendant. Letter C, a direction that the defendant answer within the time fixed by these rules. And number 4, a notice that unless the defendant so answers, plaintiff will take judgment by default and may be granted the relief applied for. To be served by the sheriff, his deputy, or may authorize the plaintiff, yan, to be served outside the judicial region, the plaintiff shall be authorized to serve the summons. Yan. If the plaintiff misrepresents that the defendant was served summons, the case shall be dismissed with prejudice. Nanghingi ng permiso yung plaintiff sa korte na siya na ang mag-serve sa defendant. Tapos nagsinungaling siya na na-serve, pero hindi naman. Madi-dismiss yung kaso with prejudice. Hindi ka na pwede magsampa. Hindi ka na pwede magsampa kasi nanloloko ka eh. Parang ganun. Wala ka ng claim. Rule 15, motions. Ito. Section 1, magkaiba, di ba, may pleadings. Yan, yung diyan nakalagay yung mga cause of action mo, ano ba problema mo, sasagutin ka ng kalaban mo. Sa summons naman, papatawag kayo. Ito naman, Rule 15, motions. A motion is an application for relief other than by a pleading. So all motions shall be in writing except those made in open court or in the course of a hearing or trial. A motion made in open court or in the course of a hearing or trial should immediately be resolved in open court after the adverse party is given the opportunity to argue his or her opposition thereto. When a motion is based on facts, facts not appearing on record, the court may hear the matter on affidavits or depositions presented by the respective parties, but the court may direct the matters be heard wholly or partly on oral testimony or depositions. A motion shall state the relief sought to be obtained and the grounds upon which it is based, and if required by these rules or necessary to prove facts alleged therein, shall be accompanied by supporting affidavits and other papers. Non-litigious motions, so motions which the court may act upon without prejudicing the rights of adverse parties, are non-litigious motions. Okay, ito yung mga motion for the issuance of an alias summons, motions for extension to file answer, motion for postponement, motion for the issuance of a writ of execution, motion for the issuance of an alias writ of execution, motion for the issuance of an order directing the sheriff to execute the final certificate of sale, and other similar motions. Non-litigious motions shall not be set for hearing and shall be resolved by the court within 5 calendar days from receipt thereof. Yan yung hindi makaka-apekto sa mga karapatan ng adverse parties. Litigious motions naman, all motions shall be served by personal service accredited, private courier, or registered mail or electronic means so as to ensure the receipt by other party. So ano naman yung mga litigious motions? Ito yung mga motion for bill of particulars, motion to dismiss, mga makaka-apekto ito. Motion for new trial, motion for reconsideration, motion for execution pending appeal, motion to amend after responsive pleading had been filed, motion to cancel statutory lien, motion for an order to break in or for the writ of demolition, motion for intervention, motion for judgment on the pleadings, motion for summary judgment, demurrer to evidence, motion to declare defendant in default, and other similar motions. The opposing party shall file his or her opposition to a litigious motion within 5 calendar days from receipt thereof. No other submissions shall be considered by the court in the resolution of the motion. Siyempre, pag nag-motion yung kabilang partido, i-oppose mo within 5 calendar days. The motion shall be resolved by the court within 15 calendar days from its receipt of the opposition thereto or upon expiration of the period to file such opposition. Kung hindi ka nag-file, i-resolve niya na yun pag natapos yung period mo to file. Doon na magbibilang yung within 15 calendar days. The court may, in the exercise of its discretion and if deemed necessary from its resolution, call a hearing on the motion. The notice of hearing shall be addressed to all parties concerned and shall specify the time and date of the hearing. No motion shall be acted upon by the court without proof of service thereof. Proof of service. Section 12, prohibited motions. The following motions shall not be allowed. So, yung motion to dismiss, ipinagbabawal yan except on the following grounds: that the court has no jurisdiction over the subject matter of the claim, that there is another action pending between the same parties for the same cause, and that the cause of action is barred by a prior judgment or by the statute of limitations. Maliban doon sa tatlong yon, wala nang motion to dismiss ang ia-allow on other grounds. Letter B, motion to hear affirmative defenses. Bawal na yan. Letter C, motion for reconsideration of the court's action on the affirmative defenses. Letter D, motion to suspend proceedings without a temporary restraining order or injunction issued by a higher court. Letter E, motion for extension of time to file pleadings, affidavits, or any other papers except a motion for extension to file an answer as provided by Section 11, Rule 11. And letter F, motion for postponement intended for delay, bawal na yun. Except if it is based on acts of God, force majeure, or physical inability of the witness to appear and testify. If the motion is granted based on such exceptions, the moving party shall be warned that the presentation of its evidence must still be terminated on the date previously agreed upon. So kung nag-grant yun, hindi ibig sabihin mauusog yung yung programa mo, bale yung time na nakalaan sa'yo para mag-present ng evidence. Pag nag-grant man ito, kailangan ma-terminate yung presentation mo ng evidence sa nakatakdang oras. So sabi ni Justice Leonen, in all instances, Rule 17 governs dismissals at the instance of the plaintiff, not the defendant. Yan. In all instances, Rule 17 governs dismissals at the instance of the plaintiff, not defendant. Dismissals upon the instance of the defendant are generally governed by Rule 16, which is deleted na, yung Rule 16 na yun. Once a case is dismissed for failure to prosecute, this has the effect of an adjudication on the merits, and it is understood to be with prejudice to filing of another action unless otherwise provided in the order of dismissal. Yan. Rule 70 is dismissal of actions. Yan. Section 1, dismissal of actions contemplates a situation where a plaintiff requests the dismissal of the case before any responsive pleading have been filed by the defendant. It is done through notice by the plaintiff and confirmation by the court. The dismissal is without prejudice unless otherwise declared by the court. Okay, so yung at the instance of the plaintiff, bago pa sumagot si defendant, nag-notify na siya sa court. So dismissal yun without prejudice. Ikalawa, contemplates a situation where a counterclaim has been pleaded by the defendant before the service on him or her of the plaintiff's motion to dismiss. It requires leave of court, and the dismissal is generally without prejudice unless otherwise declared by the court. At siya ikatatlo, contemplates dismissal due to the fault of the plaintiff, such as failure to prosecute. Yan, fatal yan. The case is dismissed either upon motion of the defendant or by the court motu proprio. Generally, the dismissal is with prejudice unless otherwise declared by the court. Yun. Unless nakalagay nga doon sa order of dismissal niya na without prejudice. Pero generally, with prejudice yun. Sasampa-sampa ka ng kaso tapos di mo ipoprosecute. Di ba? Isinasayang mo yung oras ng korte. Parang gano'n ang ibig niyang sabihin. Okay, ang haba ng civil pero civil procedure. Subukan natin tapusin tuloy-tuloy. Rule 18, pre-trial. When conducted, yan. After the last responsive pleading has been served and filed, the branch clerk of court shall issue within 5 calendar days from filing a notice of pre-trial which shall be set not later than 10 calendar days from the filing of the last responsive pleading. Ano yung nature and purpose niya? The pre-trial is mandatory and should be terminated promptly. The court shall consider, letter A, the possibility of an amicable settlement or of a submission to alternative modes of dispute resolution. Letter B, the simplification of issues. Letter C, the possibility of obtaining stipulations or admissions of facts and of documents to avoid unnecessary proof. Letter D, the limitation of the number and identification of witnesses and the setting of trial dates. Letter E, the advisability of a preliminary reference of issues to a commissioner. Letter F, the propriety of rendering judgment on the pleadings or summary judgment or of dismissing the action should a valid ground therefore be found to exist. Letter G, the requirement for the parties to Number 1, mark their respective evidence if not yet marked in the judicial affidavit of their witnesses. Ikalawa, examine and make comparisons of the adverse party's evidence vis-a-vis the copies to be marked. And number 3, manifest for the record stipulations regarding the faithfulness of the reproductions and the genuineness and due execution of the adverse party's evidence. Number 4, reserve evidence not available at the pre-trial but only in the following manner. So, for testimonial evidence by giving the name or position and the nature of the testimony of the proposed witness, and for documentary evidence and other object evidence by giving a particular description of the evidence. No reservation shall be allowed if not made in the manner described above. And letter H, such other matters as may aid in the prompt disposition of the action. The failure without just cause of a party and counsel to appear during pretrial despite notice shall result in a waiver of any objections to the faithfulness of the reproductions marked or their genuineness and due execution. The failure without just cause of a party and or counsel to bring the evidence required shall be deemed a waiver of the presentation of such evidence. The clerk of court shall prepare the minutes of the pretrial. The notice of pretrial shall include the dates respectively set for pretrial, court-annexed mediation, and judicial dispute resolution if necessary. Itong notice of pretrial shall be served on counsel or on party if he or she has no counsel. Section 4, non-appearance on a judicial dispute resolution, mediation of a party, and counsel may be excused only pag hindi ka nag-appear, kung ni-refer ka sa JDR o mediation. Pag hindi umattend yung party and counsel, it may only be excused for acts of God, force majeure, or duly substantiated physical inability. Otherwise, the case will be dismissed. Ayan. So, maganda naman ngayon, talagang ayaw na nila ng delay. Section 6, pre-trial brief. The party shall file with the court and serve on the adverse party in such manner as shall ensure the receipt thereof at least 3 calendar days before the date of the pre-trial their respective pre-trial briefs, which shall contain, among others, ayan, so may brief ka na ipapasa. Letter A, a concise statement of the case and the reliefs prayed for. Letter B, a summary of admitted facts and proposed stipulation of facts. Letter C, the main factual and legal issues to be tried or resolved. Letter D, the propriety of referral of factual issues to commissioners. Letter E, the documents or other object evidence to be marked stating the purpose thereof. Letter F, the names of the witnesses and the summary of their respective testimonies. And letter G, a brief statement of points of law and citation of authorities. So pag nagpasa, di ba, nag-pleading na, in-schedule na kayo magpasa ng pre-trial, may schedule ng pre-trial. So 3 days bago yung schedule pre-trial, magpasa ka na ng pre-trial brief mo. Tapos sa pre-trial, dadalin mo yung mga, kailangan mong dalhin mga ebidensya na imamark, judicial affidavits, ganyan. Section 10, judgment after pre-trial. Should there be no more controverted facts or no more genuine issue as to any material fact or an absence of any issue, or should the answer fail to tender an issue, the court shall, without prejudice to a party moving for judgment on the pleadings under Rule 34 or summary judgment under Rule 35, motu proprio include in the pretrial order that the case be submitted for summary judgment or judgment on the pleadings without need of position papers or memoranda. In such cases, judgment shall be rendered within 90 calendar days from the termination of the pretrial. The order of the court to submit the case for judgment pursuant to this rule shall not be subject to appeal or certiorari. Hindi mo pala pwedeng i-apila o i-certiorari yung judgment after pretrial. Ayan. Rule 19, intervention. Ito yung mga may mangingialam. Who may intervene? So, a person who has a legal interest in the matter, in litigation, or in the success of either of the parties, or an interest against both, or is so situated as to be adversely affected by a distribution or other disposition of property in the custody of the court, or of an officer thereof, may, with leave of court, be allowed to intervene in the action. So, file ka ng motion for intervention with leave of court. Ganun daw. Section 2, the motion to intervene may be filed at any time before rendition of judgment by the trial court. So, intervenor may file a complaint in intervention, may claim siya, or answer in intervention if he unites with the defending party in resisting a claim against the latter. So the answer to the complaint in intervention shall be filed within 15 calendar days from the notice of the order admitting the same. Rule 20, Section 1, the clerk of court under the direct supervision of the judge shall keep a calendar of cases for trial, those whose trials were adjourned or postponed and whose with motions to set hearing, period. Preference on habeas corpus, election, special civil actions, and those required by the law. Yan yung preference. Assignment of cases shall be done exclusively by raffle. Adequate notice to the parties. Yun. Kailangan adequately notified ang partidos. Tapos yung raffle na yon sa korte yon, nira-raffle sa bawat branch yung kung saan mapupunta yung kaso. Rule 21, subpoena. Ayan. Ang subpoena is a process directed to a person requiring him or her to attend and to testify at the hearing or the trial of an action on at any investigation conducted by competent authority or for the taking of his or her deposition. Yun ang subpoena. Ang subpoena duces tecum naman, it may also require him to bring any books, documents, or other things under his or her control. So, same manner as personal or substituted service of summons, isi-serve sa iyo yung subpoena. At ang attendance mo ay mahalaga. You are compelled to attend. If person failed to be present, the court may issue a warrant. So, contempt, failure by any person without adequate cause to obey a subpoena served upon him or her shall be deemed a contempt of the court from which the subpoena is issued. Ang exception lang is a witness who resides more than 100 kilometers to the place where he or she is to testify. So, pag ganun kalayo, ay exempted siya. Rule 22, computation of time. The day of the act or event from which the designated period of time begins to run is to be excluded and the date of performance included. If the last day of the period as thus computed falls on a Saturday, Sunday, or a legal holiday, in the place where the court sits, the time shall not run until the next working day. The day of the act that caused the interruption shall be excluded in the computation of the period. Rule 36, judgments and final orders. So a judgment or final order determining personally and directly, a judgment or final order determining the merits of the case shall be in writing, personally and directly prepared by the judge, stating clearly and distinctly the facts and the law on which it is based, signed by him and filed with the clerk of court. So, entry of judgments and final orders, if no appeal or motion for new trial or new trial based on the time provided in these rules, hindi ka nag-apila o nag-motion on time provided in these rules, the judgment or final order shall forthwith be entered by the clerk in the book of entries of judgment. The date of finality of the judgment or final order shall be deemed to be the date of each entry. The record shall contain the dispositive part of the judgment or final order and shall be signed by the clerk within a certificate that such judgment or final order has become final and executory. So, ang entry of judgment, nangyayari ito 15 days from the promulgation of judgment of conviction of the defendant. Yan. Section 6, Rule 118, an appeal must be taken within 15 days from the rendition of judgment or order appealed from. This period of perfecting an appeal shall be interrupted from the time a motion for new trial is filed until notice of the order overruling the motion shall have been served upon the defendant or his attorney. Okay, sobrang dami naman ito pero subukan natin tapusin sa isang video. Baka kulangin yung ng cellphone ko. So, nandun na tayo sa judgment. May entry of judgment pa, pero ma-i-interrupt daw, sabi, di ba, pagka may new trial. So, ano ba yung new trial na yan or reconsiderations? Rule 37, new trial or reconsiderations. Within the period for taking an appeal, within the period for taking an appeal, the aggrieved party may move the trial court to set aside the judgment or final order and grant a new trial for one or more of the following causes. Materially affecting the substantial rights of said party. So ano ba yung mga grounds para payagan ka ng korte? Letter A, fraud, accident, mistake, excusable negligence which ordinary prudence could not have guarded against, and by reason of which such aggrieved party had probably been impaired in his rights. So FAMI, fraud, accident, mistake, excusable negligence. Letter B, newly discovered evidence which he could not with reasonable diligence have discovered and produced at the trial, and which if presented would probably alter the result. So ito mahalaga yung kasyong NAPES versus CA, yung Remedy Against Denial and Fresh Period Rule. Ang kasyong NAPES versus CA. Kapag na-deny ang motion for new trial or reconsideration, that by virtue of its power to amend, repeal, and create new procedural rules in all courts, the High Court is allowing a fresh period of 15 days within which to file a notice of appeal in the RTC, counted from the receipt of the order dismissing or denying a motion for new trial or motion for reconsideration. So kapag na-deny ang iyong MR, bibigyan ka pa ng korte ng another fresh period of 15 days within which to file a notice of appeal. Naku, ang haba-haba pa nito. Punta tayo. Rule 39, execution. Lagi raw sa bar exam to. Sabi sa Section 9, execution of judgments for money. How enforced? So letter A, Section 9, Rule 39, immediate payment on demand. The officer shall enforce an execution of a judgment for money by demanding from the judgment obligor the immediate payment of the full amount stated in the writ of execution and all lawful fees. The judgment obligor shall pay in cash, certified bank check payable to the judgment obligee, or any other form of payments acceptable to the latter, the amount of the judgment debt under the proper receipt directly to the judgment obligee or his authorized representative. Lawful fees shall be handed under proper receipt to the executing sheriff, who shall turn over the said amount within the same day to the clerk of court that issued the writ. Yan, the turnover niya sa clerk of court that issued the writ. Issued the writ of judgment. Of the judgment obligee or his authorized representative. If the judgment obligee or his authorized representative is not present to receive payment, the judgment obligor shall deliver the aforesaid payment to the executing sheriff, who will then turn over the same to the clerk of court, or if the same is not practicable, deposit said amounts to a fiduciary account in the nearest government depository bank of the regional trial court of the locality. The clerk of court will arrange remittance to the judgment obligee, and if there is excess, be returned to the judgment obligor. Letter B, satisfaction of levy. If judgment obligor cannot pay all or part of the obligation in cash, certified bank, check, or any other mode of payment acceptable to the judgment obligee, the officer shall levy upon the properties of the judgment obligor. If judgment obligor does not exercise that option, the officer shall first levy personal properties, if any, and then on the real properties if the personal properties are insufficient to answer for judgment. Sheriff shall sell only a sufficient portion of the personal or real property to satisfy the judgment and lawful fees. real property, stocks, shares, debts, credits, and other personal property or any interest in either real or personal property may be levied upon in like manner and with like effect as under writ of attachment. Letter C, mga puro execution to of judgments for money. Garnishment of debts and credits. The officer may levy on debts due the judgment of obligor and other credits including bank deposits, financial interests, royalties, commissions, and other personal property not capable of manual delivery in the possession or control such credits to which the judgment of obligor is entitled. Garnishment shall cover only the amount that would satisfy the judgment and lawful fees. The garnishee shall make a written report to the court whether or not the judgment obligor has sufficient funds or credits to satisfy the amount of judgment. Garnished amount in the name of judgment obligee shall be delivered within 10 working days from service of notice on said garnishee requiring such delivery. In case of 2 or more garnishees holding deposits or credits, the judgment obligor shall have the right to indicate the garnishee or garnishees who shall be required to deliver the amount due. Section 10, execution of judgments for specific act. So conveyance, delivery of deeds, or other specific acts, vesting title. If a judgment directs a party to execute a conveyance of land or personal property or to deliver deeds or other documents, or to perform any other specific act in connection therewith, and the party fails to comply with the time specified, the court may direct the act to be done at the cost of the disobedient party by some other person appointed by the court, and the act, when so done, shall have like effect as if done by the other party. If real or personal property is situated within the Philippines, the court, in lien of directing a conveyance thereof, may by an order direct the title of any property and vest it in others, which shall have the force and effect of a conveyance executed in due form of law. Letter B, sale of real or personal property. If the judgment be for the sale of real or personal property, to sell such property, describing it, and apply the proceeds in conformity with the judgment. Letter C, delivery or restitution of real property. The officer shall demand of the person against whom the judgment for the delivery or restitution of real property is rendered, and all persons claiming rights under him, to peaceably vacate the property within 3 working days and restore possession thereof to the judgment obligee. Otherwise, the officer shall oust all such persons therefrom with the assistance, if necessary, of appropriate peace officers, and employing such means as may be reasonably necessary to retake possession and place the judgment obligee in possession of such property. Any costs, damages, rents, or profits awarded by the judgment shall be satisfied in the same manner as the judgment for money. Letter D, removal of improvements on property subject of execution. When the property subject of the execution contains improvements constructed or planted by the judgment obligor or his agent, the officer shall not destroy, the officer shall not destroy, demolish, or remove said improvements except upon special order of the court issued upon motion of the judgment obligee after the hearing and after the former has failed to remove the same within a reasonable time fixed by the court. And letter E, delivery of personal property. In judgment for the delivery of personal property, the officer shall take possession of the same and forthwith deliver it to the party entitled thereto, and satisfy any judgment for money as therein provided. Section 11, execution of special judgments. When a judgment requires the performance of any act other than those mentioned in the 2 preceding sections, a certified copy of the judgment shall be attached to the writ of execution and shall be served by the officer upon the party against whom the same is rendered, or upon any other person required thereby or by law to obey the same, and such party or person may be punished for contempt if he disobeys such judgment. Okay, so na-discuss na natin yung hanggang judgment, hanggang execution na ng judgment. Parang lasing na ako. No? Birahin na rin natin yung provisional remedies. Provisional remedies are writs and processes available during the pendency of an action to preserve and protect certain rights and interests pending the result of the final judgment in the case. So ito, wala pang resulta, pero mayroong mga remedies to protect certain rights and interests. So merong 4 daw na provisional remedies. Yung Rule 57, Preliminary Attachment. Rule 58, Preliminary Injunction. Rule 59, Receivership. And Rule 60, Rep Levin. So, kailan ba muna siya pwedeng i-avail? So, preliminary attachment may be sought at any stage of the action but before final judgment. So, the amount of bond is addressed to the sound discretion of the court. May bond siya. Ganun din ang preliminary injunction. Yan dalawang preliminary attachment at injunction, 57, 58, may be sought at any stage of the action but before final judgment. The amount is addressed to the sound discretion of the court. Amount of the bond, babayad kang bond. Rule 59, receivership may be filed at any stage of the action and even after final judgment. So bond is mandatory and the court fixes it. Yung Rule 60 naman, Rep Levin must be filed before the defendant filed his answer. The bond is double the value of the personal property seized. Meron ding isa, yung support pendente lite may be sought at any stage of the action and even for the first time on appeal. No bond generally required. So tingnan lang natin sila, yung purposes nila. Rule 57, Preliminary Attachment. The purpose is to seize the property of the debtor in advance of the final judgment and to hold it for purposes of satisfying the said judgment and to enable the court to acquire jurisdiction over the action by the actual or constructive seizure of the property in instances where summons cannot be affected. Requirements ng preliminary attachment include affidavit containing allegations as to why it should be granted, and yung bond to answer for the damages and costs which may be adjudged to the adverse party. No notice to the adverse party or hearing of the application is required. Debtor may post a counter bond to discharge the property. Yung Rule 58 naman, preliminary injunction naman, is a judicial writ process or proceedings whereby a party is ordered to do or refrain from doing a particular act. Prior notice kailangan dito. It is indispensable. Prior notice is indispensable for the issuance of a writ of preliminary injunction and a temporary restraining order. So, ang exception na to, if the matter is of extreme urgency and the applicant may suffer injustice, the court may issue ex parte TRO effective only for 72 hours from issuance, renewable after summary hearing for a period not exceeding 20 hours, which includes the original 72 hours if previously granted. So, yung mga uri daw ng injunction ay yung preventive, which prohibits a person from doing an act, and mandatory, which requires the performance of an act. The purpose of a preliminary injunction is to preserve the status quo. For example, last actual peaceable uncontested status which precedes the pending controversy. Ano naman yung receivership? Is when the court appoints a person to be the receiver in behalf of all the parties to an action for the purpose of preserving the property involved in the suit and to protect the rights of all the parties under the direction of the court. As a rule, a party to the case nor the clerk of court should not be appointed. Yan, bawal daw. I-appoint as receiver yung partido sa case or yung clerk of court. No action may be filed against the receiver without leave of court. Ex parte appointment of receiver is no longer authorized. A hearing must be conducted. Yan. Requirements, affidavit, and once again, bond. Bayad kang bond. Rule 60, Rep Levin. A party who seeks to recover a personal property, an order of may file for the issuance of an order of Rep Levin. Requirements mo rin ay affidavit and bond. Tungo tayo sa fourth topic natin, special civil actions. Diba? Ordinary civil actions, meron namang special civil actions. Ano sila? Ito yung interpleader under Rule 62, expropriation under 67, foreclosure of real estate mortgage under 68, partition under 69, and forcible entry and lawful detainer under Rule 70. So as to jurisdiction, the fact that an action is subject to special rules other than those applicable to ordinary civil actions is what makes a civil action special. Yung ordinary civil action kasi is based on a cause of action. The cause of action is defined and required in an ordinary civil action, finds no application to special civil action of declaratory relief and interpleader. Ordinary civil actions may be filed initially in either MTC or the RTC depending upon the jurisdictional amount or the nature of the action involved. On the other hand, there are special civil actions which can only be filed in an MTC, like the actions of forcible entry and unlawful detainer. Yan, MTC lang sila. There are special civil actions which cannot be commenced in the MTC, kagaya ng certiorari, prohibition, and mandamus. So, yun lang, yung pagkakaiba ng mga venue nila. As to venue, yung una as to jurisdiction, ito as to venue. The venue in ordinary civil actions is determined by either the residence of the parties where the action is personal or by the location of the property where the action is real. This dichotomy does not always apply to special civil actions. For instance, the venue in a petition for quo warranto is where the Supreme Court or the Court of Appeals sits. If the petition is commenced in any of these courts and without taking into consideration where the parties reside, it is only when the petition is lodged with the RTC that the residence is considered in venue analysis. O nga naman. Pag Supreme Court o sa Court of Appeals, walang pakialam siya kung saan ka nakatira, basta doon siya. While in ordinary civil actions, the residences of both the plaintiff and the defendant are factored in the determination ng venue, a petition for quo warranto filed in the regional trial court, a petition for a quo warranto filed in the RTC merely looks into the residence of the respondent, not the petitioner. But if the Solicitor General who commences the act and the special rule, and if the Solicitor General who commences the action, another special rule is followed because the petition may only be commenced in the regional trial court in Manila, in the Court of Appeals, or in the Supreme Court. So pag si Solgen pala nag-commence, may ibang rule. Pwede lang siya sa RTC in Manila, sa CA, or sa Supreme Court. While ordinary civil actions when filed are denominated as complaints, some special civil actions are not denominated as such but petitions. Yan. Kagaya ng declaratory relief. Yan. And other similar remedies. Review for adjudication of the COMELEC and Commission on Audit. Certiorari prohibition and mandamus, quo warranto and contempt. Special civil actions initiated by filing of complaints. Ito naman yung mga interpleader, expropriation, foreclosure of real estate mortgage, partition, forcible entry, and unlawful detainer. Jurisdiction and venue. The subject matter of a petition for declaratory relief raises issues which are not capable of pecuniary estimation and must be filed with the regional trial court. It would be an error to file the petition with the Supreme Court, which has no original jurisdiction to entertain a petition for declaratory relief. Yan ay isang jurisprudence yan under nung kaso na United Residents of Dominican Hill versus Commission on the Settlement of Land Problems. Ano naman ang interpleader? Ayon sa Rule 62, there must be two or more claimants with adverse or conflicting interests to a property in the custody or possession of the plaintiff. The plaintiff in an action for interpleader has no claim upon the subject matter of the adverse claims, or if he has an interest at all, such interest is not disputed by the claimants. Ayun, medyo naguluhan ako dun . There must be two or more claimants with adverse or conflicting interest of property in the custody of or possession of the plaintiff. Ayon. Wala siyang claim doon, si interpleader. When to file? So whenever conflicting claims upon the same subject matter or an interest which in whole or in part is not disputed by the claimants, he may bring an action against the conflicting claimant to compel them to interplead and litigate their several claims among themselves. So ano naman tong declaratory reliefs and similar remedies under Rule 63? An action for declaratory relief is brought to secure an authoritative statement of the rights and obligations of the parties under a contract or a statute for their guidance in the enforcement or compliance with the same. Thus, the purpose is to seek judicial declaration of judicial interpretation of an instrument or for a judicial declaration of a person's rights under a statute and not to ask for affirmative reliefs like injunction, damages, or any other relief beyond the purposes of the petition declared under the rules. So, nagsisik ka lang ng guidance. Ang subject matter niya ay yung deed, will, contract, or any other written instrument, statute, executive order, or legislation, ordinance, or any other governmental regulation. It is filed before there occurs any breach or violation of the deed, contract, statute, ordinance, or executive order or regulation. Fina-file mo siya bago pa magkaroon ng problema. If there has already been a breach, the appropriate ordinary civil action should be filed. Yan. It may be converted to ordinary action if before final termination, a breach would take place or his right has been violated. The similar remedies are action for reformation of an instrument. Yeah? Not an action to reform the contract but to reform the instrument. Yan. Yung instrument kung saan nakalagay yung kontrata. The instrument does not reflect the agreement of the parties although they have meeting of the minds. It is to reflect the true intentions of the parties. The reason for the reformation includes mistake, inequitable conduct, or accident. Isa pang similar na remedy sa declaratory relief ay ang consolidation of ownership. So under the law, a contract of sale may be extinguished either by legal redemption under Article 1619 or conventional redemption under Article 1610. Legal redemption or retracto legal is a statutory mandated redemption of a property previously sold. For instance, a co-owner of a property may exercise the right of redemption in case the shares of all the other co-owners or any of them are sold to a third person. The owners of adjoining land shall have the right to redemption when a piece of rural land with a size of 1 hectare or less is alienated. Conventional redemption or pacto de retro sale is one that is not mandated by the statute, but one which takes place because of the stipulation of the parties to sale. Period for redemption cannot exceed 10 years. Yeah. From the date of the contract, cannot exceed 10 years from the date of the contract. In the absence of any agreement, the redemption period shall be 4 years from the date of the contract. Yan, pag walang kasunduan, shall be 4 years from the date of the contract. In case the subject matter of the sale is a real property, yan, pag real property na, Article 1607 of the Civil Code provides that the consolidation of ownership in the vendee shall not be recorded in the registry of property without a judicial order after the vendor has been duly heard. Yan. Ano pa ba tayo? Action is brought not for the purpose of consolidating ownership of the property. Yan. Yung action for consolidation of ownership is brought hindi para pagsamasamahin yung ownership ng property to the person of the vendor or buyer. Pero ang tunay na purpose niya is for registration of the property. Yun ang tunay niyang purpose. Hindi para pagsamasamahin yung pag-aari kundi para ma-register yung property. Ano naman yung quieting of title to real property? So this action is brought to remove a cloud on title to real property. The action contemplates a situation where the instrument or a record is apparently valid or effective, but in truth and in fact invalid, ineffective, voidable, or unenforceable, and may be prejudicial to said title to real property. The plaintiff need not be in possession of the legal or unequitable title to the subject matter of the action. It may also be brought as a preventive remedy to prevent a cloud from being cast upon the title to real property or any interest therein. That is under Article 476 of the Civil Code. Ito tuloy-tuloy pa rin tayo. Special civil actions. So, ito sikat to. Rule 65, certiorari, prohibition, and mandamus. The safe office of the writ of jurisdiction, mali. Tumagos yung binasa ko. Ulitin natin. The safe office of the writ of certiorari is the correction of errors of jurisdiction, which includes the commission of grave of abuse of discretion amounting to lack of jurisdiction. A mere abuse of discretion is not enough to warrant the issuance of the writ. Certiorari is to be distinguished from prohibition by the fact that it is a corrective remedy used for the re-examination of some action of an inferior tribunal and is directed to the cause or proceeding in the lower court and not to the court itself, while prohibition is a preventive remedy issuing to restrain future action and is directed to the court itself. Ano naman yung quo warranto? Rule 66. The special civil action of quo warranto is actually a writ of inquiry that determines whether or not there is legal right to a public office, position, franchise, and may be instituted against an individual or entity as the case may be. Under the rules of court, quo warranto must be commenced by the Solicitor General of the Philippines, when directed by the President of the Philippines, or when upon complaint or otherwise he has good reason to believe that any of the following can be established by proof. So, ito yung mga pwede niyang file ng quo warranto. Number 1, a person usurps, intrudes into, or unlawfully holds or exercises public office, position, or franchise. Number 2, a public officer a public officer does suffer an act which by the provision of law constitute a ground for forfeiture of his office. And number 3, an association which acts as a corporation within the Philippines without being legally incorporated or without lawful authority so to act. Yun yung mga pwedeng file ng quo warranto. So while the rules of court do not distinguish between the kinds of franchise that may be subject to quo warranto against a de jure corporation, whether it is the primary franchise o yung certificate of registration of corporations or the secondary franchise, which is the legislative franchise, it is clear that the revocation of a corporation's certificate of registration is within the jurisdiction of the SEC. This means that the franchise referred to in the rules on quo warranto proceedings that may be instituted in courts of competent jurisdiction must refer to legislative franchise. Kaya pwedeng i-quo warranto yung ABS-CBN. Yan. Kasi legislative ang nagbibigay ng prangkisa ron. Yung mga corporation na hindi naman na SEC ang may jurisdiction, hindi sila yung subject ng quo warranto. Okay, so expropriation. Hindi ko mabasa kung anong rule siya. Expropriation, pero ano pa rin siya, under pa rin siya ng special civil actions. Expropriation is the power of the government to acquire private land for public purpose or use without the consent of the owner upon payment of just compensation. Whenever it is necessary to acquire real property for the right-of-way site or location, the appropriate implementing agency through the Office of the Solicitor General The Office of the Government Corporate Counsel or their deputized government private counsel shall immediately initiate the expropriation proceedings before the proper court under the following guidelines. So ito yung guidelines nila. Letter A, upon filing or before the filing after due notice to the defendant private owner, the implementing agency shall immediately deposit to the court in favor of the owner the sum of 100% of the value of the land based on the current relevant zonal valuation or current market value of crops and trees located within the property and the replacement cost of current market value of the improvements and structures. Yun yung expropriation dito na sinasabi. Pero yung nabasa natin under the expropriation under the local government code naman, pag inalok yung private owner, pumayag siya, sisimulan na yung expropriation proceedings, tas 15% naman doon. Dito ang sinasabi rito, under the remedial law, 100% of the value of the land based on the current relevant zonal valuation. Letter B, in case the owner is unknown after exerting due diligence or there are conflicting claims over ownership of the property, the implementing agency shall deposit the said amount to the court for the benefit of the person who is found to be entitled of the amount. If within 7 days after deposit, the court has yet to order the taking of possession in favor of the agency, they shall seek from the court the issuance of writ of possession so that they can take possession of the said property. So kung walang zonal value, BIR is mandatory within 60 days from the date of filing of the expropriation case to conduct a zonal valuation based on the land classification done by the city or municipal assessor. So ano naman tong section 4 ng RA 8974, in the event that the owner of the property contests the implementing agency's preferred value, the court shall determine the just compensation to be paid within 60 days from the date of filing of the expropriation case. Rule 68, Judicial Foreclosure. Yan. Judicial foreclosure is done by filing a complaint in the regional trial court of the place where the property is located by the mortgagee or the creditor. If after due notice and hearing, the court finds that the mortgagee creditor is entitled to the relief prayed for, the court will render judgment ordering the mortgagor or debtor to pay the amount owed to the creditor. The debtor has a chance to pay within a period of not less than 90 days, nor more than 120 days, counting from the finality of judgment. When the debtor fails to pay his obligation, the property shall be sold to the highest bidder at a public auction to satisfy the judgment, after which the sale shall be confirmed judicially. The proceeds shall be disposed in the following manner. So number 1, yung cost of the sale. Number 2, amount of principal, obligation, and interest. Number 3, encumbrances. Yan. Number 4, excess amount shall go back to the debtor. And number 5, if there is deficiency, the creditor can ask for deficiency judgment. This time, deficiency judgment can be imposed to another property of the debtor pag kinulang yung binayad sa kanya. So ano naman tong Act 3135, extrajudicial foreclosure naman ito. Yung kakabasa lang natin, judicial foreclosure under Rule 68 of the Rules of Court. Extrajudicial foreclosure naman ay matatagpuan sa Act 3135. So the creditor need not initiate an action in the court but may simply file an application before the clerk of court to secure attendance of the sheriff who will conduct the public sale. The sale cannot be made legally outside the city or province wherein the property is situated. The sale must be under a special power inserted in or attached to the rem or the thing itself, or was embodied in a separate document attached to the rem. So ano ba muna itong sinasabing special power na ito? Ito, Parties may not omit, sabi. Special power finds support in the new Civil Code of the Philippines. So, sheriff and the creditor in essence will act as agents of the debtor. Thus, there must be a written authority from the debtor, otherwise the sale shall be void. So, pahihintulutan ng debtor na umarte as agents yung sheriff and the creditor. And after the sale, the debtor or his successors in interest may redeem the property at any time within the term of 1 year from and after the date of the sale. The said period is fixed to avoid prolonged economic uncertainty over the ownership of the thing sold. Yan. Ano naman yung partition under Rule 69? So in a complaint for partition, the plaintiff seeks first, yung declaration that he is a co-owner of the subject properties, and second, the conveyance of his lawful shares. In an action for partition, heirs, but also persons claiming interests or rights in the property subject of partition are indispensable parties. So yung mga pinagkakautangan at yung mga tagapagmana, indispensable parties sila. Indispensable parties. Ano ba yung indispensable parties? Without their presence in the suit, the judgment of the court cannot attain real finality against them. Okay, kanina napahapyawan na natin yung Rule 70, yung forcible entry and unlawful detainer. So, no demand to vacate required. Yan. So, in forcible entry, one is deprived of physical possession of any land or building by means of force, threat, intimidation, strategy, or stealth. Physical possession or possession, not legal possession. Yan. So, yung isang tao, dineprive siya ng physical possession. So, de facto. Yan. Unlawful detainer naman is in unlawful detainer, one unlawfully withholds possession thereof after the expiration or termination of his right to hold possession under any contract, express or implied. Itong unlawful detainer should be filed within 1 year from the date of the last demand to vacate. Failure to do so, magiging ordinary civil action na siya of action publicana. Yun ang magiging appropriate remedy mo pag di ka nag-file ng unlawful detainer within 1 year from the last demand to vacate. Yan. Action publicana. So, for ejectment, ayan, not filed within 1 year. Ayan. Action with notice to the public is a remedy to recover a better right to possess. Yan, yung de jure. That is the only issue, yung karapatan mo to possess. So, ang prescription niyan ng action publicana ay 10 years. Expanded law increased the jurisdictional amount cognizable by the regional trial court in all civil actions to 400,000 whether Manila or outside. Ayun nga yung nabasa rin natin sa previous video natin. 400,000 and above. Ayan. Na civil actions. Ano naman yung, so ulitin natin. Ang unlawful detainer, kailangan mo siyang i-file within 1 year from the date of the last demand to vacate the property. Pag lumagpas ka ron, hindi na pwede yung unlawful detainer. Magiging action publicana na siya. Yun. Ejectment. Yun na yung tama mong gamiting remedy. Yun nga lang, talagang maglilitigate ka na talaga ng mabigat. So, nabanggit natin action publicana, which is yung ejectment. Ano naman yung action reinvindicatoria? So, action reinvindicatoria is a remedy to recover immovable property. Ingay immovable property. This action involves recovery of ownership of real property, including but not limited to possession. So, ownership and possession. This action has a prescription period of 30 years. Okay, contempt of court rule 71 is a defiance of the authority, justice, or dignity of the court. Rule 71 provides for two, Solid ang banat ng motor natin Ayan. So Rule 71 provides for two forms of contempt. So yung direct contempt, which is a willful and deliberate violation of the rule against forum shopping, is a ground for summary dismissal of the case and may also constitute direct contempt. Yan. Direct contempt pala yun. An order of direct contempt is not immediately executory or enforceable. The contemnor must be afforded a reasonable remedy to extricate or purge himself of the contempt. Yan. Yun ang direct contempt. Willful and deliberate violation of the rule against forum shopping. Ground pa siya for summary dismissal of the case. Indirect contempt naman refers to the contumacious acts. Wow, lupit ng word. Contumacious acts perpetrated outside of the sitting court and may include misbehavior of an officer of a court in the performance of his official duties or his official transactions, disobedience or resistance to a lawful writ, process, order, judgment, or command of a court, or injunction granted by a court or judge, any abuse or any unlawful interference with the processes or proceedings of a court not constituting direct contempt. So pag direct, not an officer of the court. Pag indirect, officer siya of the court. Yan. So, naalala ko mayroon akong maling ginawang decision dyan. Indirect contempt. Hindi naman siya officer of the court. So, kulang sa aral. Yan. O, doon na muna tayo magtatapos. Itutuloy natin yung next video natin. Special proceedings, yung mga susunod. Tapos yung criminal procedure, evidence, marami pa. Tapos yung procedure sa anong tawag dito? Post-judgment remedies other than appeal, mga ganyan. Appeals in civil procedure. Ano pa tayo mga babasahin? And procedure in tax cases. So, masipag tayong magbasa-basa sa ngalan ng content. So, babay muna.